Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everyone, welcome into an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph L. Jordan, the founder of Jordan UCMJ Law Group. I'm your host, Mike Leon. Joseph here is a former Army JAG. He's a worldwide court-martial defense attorney who's tried more than 240 court-martials to verdict and handled more than 350 military cases all across the United States, Europe, the Pacific, and in the Middle East. Today's episode, we're going to be talking about the investigation stage and portion, how service members are coached to navigate CID interviews, command scrutiny, and long periods of uncertainty while the case is taking shape. Joseph, it's good to see you as always. I'm curious about, especially once an investigation is underway with these type of cases and trials, what do you focus on first when you're working with, a service member who's under intense scrutiny from the command and the investigators?
Thank you again, Mike. It's good to see you. What do I focus on first? Expectation management. It's really important for the service member to understand what to expect moving forward. When someone is under investigation, an investigation could be very short or it could be very long. And more often than not, it's long. And so they have to know and understand what the collateral consequences are to a lengthy investigation, how to operate within their unit, what their daily battle rhythm needs to be. They need to be a force multiplier for the unit. They're still getting paid on the 1st and the 15th. So if they got to scrub a toilet with a toothbrush, then that's what they need to do. And with a smile on their face, they got to be the best trooper, airman, Marine, sailor that they possibly can be.
And let me ask you, because CID interviews, and you can explain what the acronym means, I'm sure they carry a lot of weight. What makes that stage especially risky for the service member if they don't fully understand what's happening around them?
So CID is Criminal Investigation Division for the United States Army. The Marine Corps also has their own version of that. So as it relates to service members and how they deal with that, first and foremost, there's a danger that they could make a mistake, right? That they could over-explain something, that they could inadvertently lie, or that they could be forced into a lie. And sometimes that happens. They make a statement. One of the more common things that I see is oftentimes service members, especially the younger ones, will feel bad about a situation. Maybe I could have handled that a little differently, or maybe I pushed the situation a little too far. And CID kind of has this psychological effect on them wherein they try to get them to apologize. And then they will indeed apologize. They'll either do it verbally through the audiovisual interview process that they're doing, or they will do a written note. They'll either handwrite it or they'll write it in on a computer or something of that nature. And a lot of times service members just don't understand that just because that individual says that they work for the Army, the Navy, the Marine Corps, the Air Force, doesn't mean that they have their best interests at heart. And so it always amazes me that these young service members, 17 to their mid-20s, don't understand that they have a right to remain silent and that they don't need to talk. And maybe some of them feel like telling integrity is everything in the military. So that maybe they feel like if they're not going to speak, then it looks bad because they're not, it looks like they're hiding something. Stop. Put that out of your mind and remain silent and call an attorney.
Is that the only mistake that you've seen in these situations? It's that it's too quick to talk and defend themselves. Like should always every person that's listening to this that's potentially being investigated or could potentially be charged, is it just shut up and wait for me to get there? Is that the advice? Or are there other things that you've seen that they've made mistakes on?
First and foremost, yes, that's the advice. You hit the nail on the head. Second, sometimes service members find out they're under investigation, and before they get hauled in to be questioned, the first thing they do is they pull out their phone and they delete all their text messages, their photographs, whatever. So if it's a sexual assault or it's a domestic violence issue or any issue, doesn't matter. there's communications there that they think are not helpful to them, the first thing they do is they delete them. I hate it when they do that, because oftentimes these young kids don't understand that uh, there are great text messages in there that show a desire, a willingness, an intent to engage in certain activities with the accused, right? So if it's a sexual assault case and you have an individual texting them and saying, hey, I want to be with you. I want you to come over to my barracks room or my dormitory room or my house for sex or whatever, that shows intent, right? And that's really important to assess the veracity of the claim of sexual assault, domestic violence, or whatever the crime may be.
Beyond the investigations and the investigators, I'm sure the command attention can also add another layer of pressure. Explain for our audience what that pressure is, and how does that environment kind of affect the way people behave, especially while the case is forming?
Our society, we're supposed to be innocent until proven guilty. In the military, it doesn't seem to operate that way. Commanders make decisions to protect their command. And so, in so doing, because of the amount of scrutiny that's come down from Congress and society at large, you oftentimes will be pulling service members from privileged positions. You're under investigation for a crime. So what happens? In the Army, you're flagged. What does that mean? There's a marker that's put in your file that says you can't go to schools, you can't PCS to a new duty station, you can't promote, those sorts of things, right? Most of the services have a similar type of mechanism. But the scrutiny that the unit gives these service members is withering in some cases. They oftentimes will pass judgment before the case even gets into the courtroom. And that puts a lot of pressure on the service member, and it's mentally taxing. It's anxiety. There's a lot of anxiety that comes with that. And so oftentimes they call attorneys counselors. And sometimes I have to step into that role as a counselor. It's not my favorite role, but sometimes we have to do that because the scrutiny from the command in terms of how they're treated, and then by virtue of the regulations. So, yeah, what you have to understand, in the Army in particular, it's regulatory, right? You're under investigation. You don't get to do all these privileged things, such as promote, go on to a new duty station, go to schools to enhance your abilities to be a better service member within the Army, a better soldier within the Army. And the other services have those same mechanisms to a certain degree. But it's taxing on the service member, and it's tough. They don't understand why they are put through this process. They're supposed to be innocent until proven guilty, but by virtue of the rules and regulations in place, they go through the crucible of a taxing investigation and all of the scrutiny and discrimination that comes with it.
Joseph, let me ask you, because I'm sure you've seen cases where the damage wasn't just caused by the allegation itself, some of the choices made during the investigation, like you said about deleting text message exchange. But what are some other patterns that have kind of stood out to you over the years from that overlap?
So the deletion of text messaging is the number one issue that I see. And that nests well with the idea of any physical attempt to destroy evidence or remove evidence. So if you are accused of, stealing something, or I don't know, forging documentation, those sorts of things. Those are people feel like they need to do a certain thing in order to affect a certain outcome. Why? It's not necessarily because they're a bad actor. It's really because they're just scared and they don't know what else to do, and maybe they don't trust the system. Right? So there's two spectrums here that we've talked about. We got some people that trust the spectrum too much and they just want to spill the beans and tell them everything. And we got other people that don't trust the system at all, and they don't trust it to the point that I'm going to cover up as much as I can, as as fast as I can. I'm going to go to witnesses and I'm going to tell them, don't talk to investigators. I see that a lot. I'm going to go and I'm going to hide evidence. I see that a lot. We've had situations where I had a trial a long time ago. It was almost 15 years ago, for a senior NCO in the Air Force, where he was accused of a lot of white collar crime stuff. He was acquitted of that. We'll talk about that case, episodes later. But the number one issue that popped out of that thing when I do kind of an after action review of that case was he was also accused of misappropriating parachutes. And in that particular situation, he had them stored outside the base. Did he misappropriate them? No. And he wasn't found guilty of that, even though he was charged with it. But what he was accused of was obstruction of justice, and he was convicted of that. Why? Because he went to the storage place where the parachutes were held, and he grabbed them, and he took them back to the unit. And for some reason, that counted as obstruction of justice. It is obstruction of justice. I misspoke there. It's weird. I don't know that I would have actually, if I was sitting on the jury, I would have convicted him of that. But that's what he went down for. It was a weird situation. Had he not went and got those out of the locker, he wouldn't have been convicted of that. So just that physical removal of evidence is a big one.
Well, there's the physical part, but then there's also like the mental part, right? He chose to do that. So how in those type of scenarios, how do you work with clients? Keep the emotions, the fear out, all the outside noise from driving crazy decisions like that person made with respect to before the trial even happened.
So in that scenario, I didn't know he did it, right? That was done, I think it may have been done before I even came on the case. But there are occasions where service members will try to do things after I've come on board, after they've been accused, the investigation's underway. And really what you want to do is you need good communication with the client, good expectation management at the outset, telling them what to expect. I have a welcome letter that I give them that really outlines all of the things that they need to know, that they need to expect, the do's and don'ts of how to conduct yourself while you're on investigation. And so coupled with that, some of my clients require more attention than others. And some of it force it by constant phone calls and emails. But others I recognize at the outset, based off of our initial interview, my review of their narrative, talking to witnesses, I start to realize, they're going to need a little bit more attention. So my staff and I come up with a battle rhythm where we're in communication with them. Also, if there's a co-counsel involved, we share the duties of staying on top of the client and making sure that they don't create a minefield for themselves.
Staying with that, can you share a couple case examples where some steady coaching during especially the investigation portion of this made a huge difference in how the rest of the case, unfolded? What kind of stood out to you about the situations?
So my Army example, it was with a special forces augmentee, and he was accused. So there's different things you can do in the military with punishing a service member. One of them is you can give a service member an Article 15. So it's an administrative remedy wherein we accuse you of a crime, but we're not going to take you to court for it. What we're going to do is we're going to bust you in rank, take some money, give you some extra duty to correct behavior. And in this case, my client had come up hot on a drug test for marijuana. And I started investigating the case. And when I reviewed the paperwork, I found that actually he didn't come up hot. I misspoke. What happened was they accused him of adulterating his sample. That's what he was accused of. He was accused of adulterating a sample. He didn't come up hot. And so in that scenario, I had a statement from the observer that watched him urinate into the cup. And he said, I watched him urinate. I watched him put the lid on. I watched him seal it. I watched him hand it to the individuals that are monitoring and accounting for the urinalysis. And I'm thinking, what are we doing here? So I advised my client to turn the Article 15 down and request trial by court-martial, which is his right. Because the commanders oftentimes, if they're writing the Article 15, they're going to give him the Article 15. They're going to bust him in rank and those sorts of things. And this individual was up against a retention control point. He really didn't have a choice. He needed to turn it down, request trial by court-martial, especially since he didn't do it. So he was scared. He was working in a SF world. And so I had to constantly remind him, hey, we've got the juice. Look at this statement. I had to constantly remind him of that. They charged him. And then I called up the brigade judge advocate and I said, what are you doing? Did you look at this evidence? And so he pulled it back. And they decided, well, we're going to give him a reprimand. And so I wrote up a very lengthy response to that. But the whole time, my client is anxiety ridden. He did not, he wasn't comfortable with the idea of going to court on this. And many service members aren't. But we had the juice. Okay? We had the juice. And so, we won that case. No court-martial conviction. The reprimand was actually thrown out. So it was a great victory for him. But he had a lot of anxiety along the way. My second case was an Air Force case. My client was accused of misappropriating a piece of property. It was an equipment. He also was in the Special Forces world. He did SEER training. SEER is survival, evasion, resistance, escape. It's SEER training for pilots, which is something that they have to do on a regular basis. And this was for U-2 pilots, which is vital. They have to certify it on it every single year. So it's the evasion, those techniques. So in his case, he was accused of taking a what's called a razor, which is it's a UTV, utility vehicle. And what happened with the vehicle was they went out, they were doing a training operation, and it caught on fire and burned to the ground. And I investigated the case, and when we looked at what he was accused of, one, misappropriating it, and two, causing it to burn down, so negligence. And there was a couple other things that were involved in that. What we had found out was that his supervisor had told investigators that he did not authorize our client to take the vehicle out into the Mojave Desert to do this training that they were doing, which was a complete and utter lie. A witness had come forward. We had interviewed them, recorded the interview, and found out that it was the exact opposite. This witness had overheard the whole conversation, and it was the exact opposite of what my client's supervisor had said. Again, he was facing an Article 15, and I said, you need to turn this down. This is a win. And again, a lot of anxiety with that decision, because is it a roll of the dice? Sure. But I'm pretty sure I'm gonna drop sixes on this one. All right. I'm gonna drop double sixes. Why? Got juice.
Right.
The unit doubled down on this, and they added charges to the case, which added more anxiety to our client. They said they added that he caused to destroy equipment that was on the razor. So they had these razors, they have, equipment pouches on them with first aid kits, with tools, with all kinds of stuff. So
Right.
he was charged with the destruction of all of that property as well. And yeah, there's a lot of anxiety that came with that for him. And we had to constantly reassure him, we've got it. And we built out a great litigation team for him. And we went in there and we won the case for him. But we had to keep him on course the whole time.
Yeah. So, Joseph, for someone that's listening, they've never been to a military investigation, what should they understand? What's one thing you would want them quickly to understand about how these early decisions can quietly shape everything that comes later on?
It's everything. These early decisions will affect the overall outcome of the case. If you're listening to your counsel and you're patient, the right outcome usually occurs. When you bring on somebody to represent you, you got to trust that their interests, that they are taking your best interests at heart. You got to trust them. You're relying on them to make the right decisions for you. You got to listen to them. You got to be patient. Patience is extraordinarily key in this process.
Yep. Patience is a virtue. Joseph, thank you so much for the time, the insights. I appreciate it as always.
Thank you, Mike.
And thank you to everyone out there for listening to this installment of Courtroom Quarterback with attorney Joseph Jordan. To learn more about Joseph's worldwide court-martial defense practice, do me a favor right now, visit jordanucmjlaw.com. Don't forget to like, subscribe, leave a review, or share the episode with someone who needs to hear it. I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.